Now I've got the webcam, people are happy. Thank you very much, everybody, for coming today. My name is Tim Wilson. I'm Australia's Human Rights Commissioner, and it's a great pleasure to have you all here at the Australian Human Rights Commission as part of our RightTalk lecture series. I'd like to begin by acknowledging the Gadigal people of the Eora Nation, whose land we meet on today, and pay respect to their elders, past and present, but also to introduce the guest we have today, Jon. We invited Jon to speak at the Australian Human Rights Commission because, as many of you in the audience will well know, while we have traditional debates about free speech and privacy and individual liberty, it's on the online platforms and in the internet that we so often, and through the realms of technology, meet the frontiers in every sense of the challenges we face in individual liberty, least because governments, and I say this with great thanks, struggle to regulate the internet and technology because it is so manifest in the different ways it can express itself, because it is so decentralized, and because it provides great opportunities for human flourishing and endeavor. But of course, we also know that the internet collates the sewer of our thoughts and some of our worst human instincts. So how do we find that balance and the tension between human rights and individual liberty, and of course, managing the tensions that exist between making sure people feel safe and capable of participating online, preserving and protecting privacy while dealing with serious issues of crime and many other subjects? These, of course, are topics that have come up a lot recently as a consequence of national security legislation and the role the internet can play as a direct consequence of promoting terrorism or engaging in terrorist activity. Similarly, issues around child pedophilia and access to technology. And of course, one of the most recent debates, which is still sort of ongoing, but probably in my opinion hasn't been discussed nearly enough, has been around the role of data retention as a mechanism to deal with ensuring accountability on online platforms while also making sure we secure privacy. So to talk about these and many other issues today, we are of course enormously grateful to have Jon Lawrence come and speak to us. Jon is the head of the Electronic Frontiers Australia, which is celebrating its 20th anniversary this year. 21st anniversary, which means it is now fully adult.
Yes.
This year. Jon is the head and has had more than 20 years of experience in the IT and internet industries, primarily in product and relationship development roles. He has worked in Australia, the United Kingdom, Denmark, and the United States for a wide range of commercial organisations, from 4-person startups to large-scale media companies. He has been an interested observer of ICANN and the international internet governance field since 1999. His other areas of policy interest include freedom of speech in the online context, privacy, copyright law reform, and bridging the digital divide. He has a Bachelor of Arts with majors in modern history and political science from Open University UK, and a Master of International Relations from the University of Melbourne. He joined EFA in 2009 and served on the EFA board from September 2011 to April 2012, when he resigned in order to take up his current role as the part-time executive director. Jon, we are enormously grateful that you have used your part-time responsibilities today to come and speak to us. For those of us in the room and also for those on the internet, we wave and say hello. Jon is going to come and give a short presentation to outline some of the issues and concerns of EFA in the context of human rights. Then we'll have a discussion, an opportunity for you to ask questions and lead a discussion. Ladies and gentlemen, will you please welcome Jon Lawrence.
Thanks. Thanks very much, Tim. That was quite a comprehensive introduction, and I'd like to say that I'm really quite honoured to be here at the Human Rights Commission today. I think as somebody that is acutely aware that this country particularly lacks many of the constitutional protections around issues relating to privacy and freedom of expression, particularly that our friends in the European Union and the United States enjoy, I think it's really important that this institution exists and continues to do its excellent work. Oh, there's always one. Look, Tim has actually sort of stolen a lot of my introduction there, which is fine. I'm going to talk really briefly about sort of what are digital rights. I think given the venue and the audience, you probably don't need me to lecture you on human rights. But, what are digital rights? Well, they're human rights in the digital context. So that was easy. Essentially, I would say there are sort of three primary issues here. Privacy, as Tim's alluded to, freedom of expression, and also particularly equity of access. It's interesting that there are certain countries in the world where the right to access the internet has actually now been written into their constitution as a basic human right, Finland being the example that I have in front of me here, but I believe there are others as well. I think Brazil is also doing some interesting work in this space. So given that we now live in what is essentially a almost ubiquitously digital context, I mean, for example, is there anyone in the room that does not have a smartphone on them? Oh, okay, impressive. How many people in the room have more than one smartphone on them? Okay, good. So yeah, we're all part of the digital revolution. I think as particularly, I suspect most of the people in this room would in some way identify themselves as knowledge workers. We kind of all exist in the internet. So these issues are pretty front and center to most of what we do. Are these first world problems? I would argue probably not. I think particularly as mobile internet rolls out across the world, even you can go to Kenya and look at the revolution that's happened there in terms of mobile-based financial transactions and so forth. Even people that can't afford houses are transacting on the internet, as it were. So there are genuine issues there that I think go well beyond the context of just issues that us lucky people in the developed world have to deal with. So what's the digital rights movement all about? Well, as Tim's mentioned, EFA has been around for, this is our 22nd year. That's a long time for a small organisation such as ours to have existed. We've gone through some pretty big highs and lows in that context, in that history. We continue to struggle partly because Australian tax law is not terribly friendly to organisations like us to sustain ourselves. So if anyone there is thinking about joining, please do. But what are we about? I think the reality is that we're as much about education as we are about advocacy. I think it's fairly obvious that the general level of technical understanding amongst policymakers in this country, and I think most countries, is actually really quite dangerously poor. I think there are some good people in Parliament who understand what this is all about, and I should note here, because she retired yesterday, but Senator Kate Lundy was a particularly good policymaker with an excellent understanding of the sorts of issues that we deal with, has been a very good friend of our organisation and others for a long time, and we'll certainly miss her in the Senate. But there are plenty of others as well within Parliament that do understand enough about these issues to make what I would call sort of informed policy choices. But we've got a lot of work to do there, I think, and that's something that, and I'll touch on this, something that, where's Laurie? Where's he gone? Oh. Something that we've been doing some work with in my other hat, which is I'm also a non-executive director of the Internet Society of Australia, and that's something that we're actively working on to try and improve. Anyway, so I'll touch on quickly just the sort of three main policy areas. I'll give a little bit of a very brief history of the movement, and then I'll sort of talk about very quickly sort of the main issues that we're currently dealing with, and then we can unpack some of those in the Q&A. So, is privacy dead in the digital world? Well, I would suggest not. I think it's important for people to understand what privacy actually is, and I think it's a very widely misunderstood term. Privacy is not about secrecy. Privacy is about choice. Privacy is about you having the ability to make choices about who gets access to your personal information. That personal information, particularly in a world of Facebook and Google and Twitter and so forth, and ubiquitous online advertising, is really at the core of many of the power structures that we deal with in this world today. It's clearly a key issue in our relationships with government, e.g. data retention, etc. It's clearly a key issue in our relationships with most of the large corporations that we deal with on a daily basis. So that's a really important issue. We have a new Privacy Act, as many of you would be aware, that came into effect just recently. Does that go far enough? We would argue probably not. There are really quite serious limitations on that act, such as the fact that it really, with some exceptions, doesn't apply to organisations with turnovers under $3 million, for example. So we'd like to see that extended. But that's a key issue. We can talk about that more in due course. Freedom of expression, clearly another major issue. The internet and the digital context more generally, clearly, without question, the single most powerful enabler of free expression that's ever occurred in human history. But it's also, in many ways, arguably the single most powerful form and platform of surveillance and censorship that's ever been invented. So there's a genuine struggle there between those two issues that we continue to have to deal with. So freedom of expression is under constant threat from government, and that's in the nature of government to control speech. That's just what they do, and I think it's not unfair to suggest that our current government is particularly, what's the right verb here, particularly resistant to transparency on many issues, and I think that's something that is a genuine cause for concern. But we also have, large global private companies that are making decisions about freedom of expression that I think can be quite problematic. So should Facebook and YouTube really be the arbiters of what is acceptable speech online? Do they want that job? Probably not. Do they genuinely try to establish global norms that they feel are appropriate? Yeah, I think they do. Do they get it right every time? Of course not. But as private companies that are effectively managing what are really public spaces now, I think there's a really interesting discussion that needs to happen there. One example of current government approaches to freedom of expression is the recently appointed e-safety commissioner. The individual involved, Alistair McGibbon, is I think probably an excellent choice. He's a genuinely expert practitioner in this area, but the powers that role have been given are, I think, really quite problematic. It is essentially the situation that you have a bureaucrat with the power to direct content to be removed from the internet. So that's something that I think we need to keep an eye on. I think, as I said, I think Alice is an excellent choice, but the powers of that role, I think, are quite problematic. Finally, onto the issue of equity of access. This is the digital divide, and I think that's as much an issue here in Australia as it is potentially, in the developing world. I think we look at particularly regional internet access issues, internet connectivity speeds, and so forth. There are serious issues there that need to be dealt with, and I think. From my perspective, I think it's actually really quite a no-brainer in that if you are able to provide genuinely high-quality speeds of connectivity, and that means both download speeds and, of course, upload speeds as well, in the regional environment, I think that will actually go a long way towards addressing many of the fundamental economic challenges that our regions currently deal with. So, a very quick history of the digital rights movement. The digital rights movement essentially emerged in the San Francisco Bay Area, not unsurprisingly, in the very late 80s into 1990. Our sister organisation in the US, the Electronic Frontier Foundation, was founded in 1990 off the back of what was essentially some pretty ill-informed government overreach in terms of what was alleged to be computer crimes. It was founded by a group of people, including John Perry Barlow, who was the lyricist for the Grateful Dead. And there was back then, and I think this still exists to some extent, a real kind of digital utopian hope and underlying issues there that I think have kind of largely, what's the best way to say this? I think those issues are still there, and I think I buy into them to some extent in the sense that, and Tim touched on this in his introduction, that the internet is a pretty fundamental threat to our sort of established Westphalian juridical sovereignty norms, and pretty fundamental threat to sort of government as it's currently constituted. But I think to some extent that sort of digital utopianism has largely given way to slightly more pragmatic concerns as the movement has evolved. So 1990, EFF was formed. Now, important to note that EFF and EFA are very closely aligned. We share most of the same goals. We talk on an almost daily basis, but we are not formally linked in any way. We certainly don't enjoy any of the quite significant funding that they're able to raise in the US. EFA was formed in 1994, not long after, essentially on the sort of same basis that EFF was. It was actually formed in Adelaide, of all places. Still not entirely sure why, but I wasn't there, so that's fine. And we have sort of sister organisations around the world, as you'd expect, and particularly within the Five Eyes countries, so the UK, Canada, New Zealand, and the US. So in the UK, our friends are the Open Rights Group, who've been doing some excellent work recently, also working with our other excellent friends at Privacy International, suing GCHQ and winning over their illegal use of intelligence gathered by the NSA. So that's been an interesting fight. Our friends in Canada are Open Media, who are doing some great work as well, particularly in terms of net neutrality and other issues that are hot topics in North America. And in New Zealand, our friends are the guys at Tech Liberty, which is an even smaller organisation than we are. There's also a pan-European entity called the European Digital Rights Agency. I forget what the I stands for, and they've been around for a while, and that's kind of an umbrella group, as you'd expect. And the last one I'd like to mention is the Internet Society. And I mention that partly because I'm obviously involved in it, but it's also an interesting entity in the sense that it is a truly global organisation with local chapters in most places, such as of course Australia. The Internet Society was actually originally founded by the actual engineers that built the internet. So people like Vint Cerf, who was one of the authors of the underlying TCP/IP protocol. I won't go into any detail on that because it gets very nerdy very quickly, but the core mission of the Internet Society is that the internet is for everyone. So it's really about bridging that digital divide. They do a lot of excellent work in the developing world in terms of capacity building, establishing internet exchange points, which are very critical infrastructure that enables domestic connectivity to expand dramatically. And as I mentioned earlier, we're doing some pretty proactive work here locally in terms of trying to establish some structures that help us to enhance the technical understanding of policymakers, because that's clearly something that is well overdue. So I'll just quickly run through the hot issues that we're dealing with at the moment, and then we can start to unpack some of those in the Q&A. Clearly, data retention and mass surveillance is a pretty hot topic. I believe the government's data retention bill is going to probably clear the Senate today, possibly tomorrow, depending on how they arrange their schedule. We've also got another bill that's due to be introduced, I believe, today or tomorrow, which will establish the ability for copyright rights holders to get federal court injunctions to have offshore websites blocked if they are able to demonstrate to a judge that those websites are essentially just enabling copyright infringement is the right word. So that is, by definition, an act of censorship. That's something we have some pretty significant concerns with, not least because we think it's going to be entirely futile. But we can talk about that. So there are real issues around copyright enforcement. You may be aware also that there is an industry code being in the final stages of being drafted by the Communications Alliance, which is the ISP Industry Association, and that's around providing rights holders the ability to have notices sent to end users if they're alleged to have infringed copyright. Piracy is the common term. I try to avoid it, but that's, I think, what we all understand. So that's coming. That's likely to be implemented later this year, maybe around September. Clearly, privacy is an ongoing concern, and most of the issues that we deal with have some element of privacy associated with them. And a nod to Mark from the Australian Privacy Foundation. Nice to see you. Clearly, censorship's an issue. I mentioned the website blocking bill. I also mentioned the e-safety commissioner, and that's, again, another censorship program which can potentially have some pretty serious unintended consequences. And then 3 more points. There's this lovely issue of data sovereignty, which has come up recently, particularly around the idea of data retention and exactly where that data is hosted. Do we really want that hosted in China? Is that an issue? Possibly not. That taps into the Trans-Pacific Partnership Agreement negotiations, which, while of course they're entirely secret, we do understand could potentially impose restrictions on the Australian government, for example, actually carving out the ability to say that this particular set of data should be hosted on shore. So that's an interesting one. Net neutrality has been a pretty hot topic in North America, as many of you would probably know. It's less of an issue here for a number of reasons, although it will become so. But net neutrality is essentially about the ability of ISPs and content distribution platforms to do deals that prioritize certain traffic over others. So if you understand that in North America right now, about 30% of all internet traffic is Netflix. You can understand how the ISPs might, particularly given that most of them are cable companies as well, who of course have their own TV distribution channels they want to protect, how they might want to do a deal with Netflix and say, hey, we're doing a lot of heavy lifting for you. How about you pay us to make sure that your videos don't buffer? The Obama or the FCC rather, which is actually statutory, independent statutory body, I believe, in the US, has actually made some rules to essentially prevent those deals from occurring. That's a pretty interesting issue. It's likely to become, as I said, an issue here in Australia as we see, for example, Foxtel move into the ISP market, which they're about to do. So that's an interesting one. And last but not least, and also because Tim gave an excellent speech for me at a conference we ran last year on the right to be forgotten. Now, this is an interesting issue that came up from a European Court of Justice decision last year, which essentially gives people the ability to have certain information removed from the Google index. And that's an interesting discussion around censorship. Who should be making these decisions? Should it be Google? I suspect probably not, and we can talk about that if you want. But That's kind of all I had. Should we start to unpack some of these issues?
Right.
Oh, there's water over there.
Thanks. Now, there we go. Thanks very much, John, for that overview of what the EFA is up to, what you're up to, and the key issues you see that are relevant at the moment. I'm very happy to take questions from the floor, so if anybody has anything to ask, don't hesitate to put your hand up. But I think we might start directly with the key sort of issues of the day, and I'm not talking about Netflix launching, although I understand their pricing policies are very good, according to many commentators, is around data retention, because that is obviously one of the biggest issues that's going through the Parliament right now. And there seems to be a lot of, at least from viewing the internet and Twitter, people have very, very strong views about the fact that they don't think data retention is legitimate in any form, one way or the other. Yet we have this great challenge, which is there is more and more activity that occurs exclusively online. What is the EFA's view and your view about how we manage the need for accountability online, particularly when people are engaging with conduct which is offline, otherwise unlawful or criminal?
Yeah, no, excellent question. Couple of points I think to sort of make to start with. Firstly, the reality is that there's a hell of a lot of data retention going on already. In that sense, there are parts of this legislation which are actually really important, urgent reforms, particularly around limiting the agencies that can access this information. I think we'd all probably agree that the Victorian Taxi Directorate, Bankstown City Council, etc., can probably survive without warrantless access to this information. So that's actually a really important thing. So that part of it we definitely support. The reality is that much of the data that's wrapped up in this, particularly around phone records, is being retained by telcos for legitimate billing purposes already. And if you go back to look at sort of the Australian privacy principles in the Privacy Act, the core issue there is that data should not be retained unless there is a legitimate sort of operational purpose for it. So to that extent, look, that's consistent with the Privacy Act. We would prefer it wasn't happening, but it's there. Should the police and ASIO have access to that? Well, yeah, probably under sort of with certain safeguards, of course. What this Act does do is it does force particularly ISPs to actually start retaining data which they don't currently retain and for which they have no business purpose to do so. And that's particularly around what we call source IP address information. So that's the address that's assigned to you every time you connect to the internet. Particularly in a mobile device world, that is something that potentially can change many times a day. Your home Wi-Fi router, if you don't reboot that, you may have the same IP address for 3 months. So, those things are quite fluid. That information, as I said, most ISPs or some ISPs have no reason to collect, and so they don't. So this bill is forcing the collection of new data, and particularly keeping it for 2 years is, we think, way too long, and we're certainly not aware of any evidence that supports that two-year retention timeframe. In terms of sort of safeguards around access, the work that the Labor Party particularly have done in sort of adding some additional protections for journalists is, I think, interesting. I think in reality, that's more about providing political cover than actually providing any meaningful protection for journalists. But from our perspective, we see that as a start and a first step towards what we would like to see, which is an entire sort of independent judicial warrant process for access to this information. So that's sort of where we're going from here. Okay, we've got a little beachhead. We're going to try and extend that, because I can't see any reason why a lawyer-client relationship is any less worthy of protection than a journalist-source relationship, psychiatrist and a patient. You know, we could go on. I think it's really important that we actually have proper independent oversight of access to this information.
Thank you very much. And it was remiss of me, I didn't realise she was in the audience. The President of the Human Rights Commission, Professor Gillian Triggs, is in the room. I'd like to acknowledge her and thank her for coming. Does anybody have any questions? Oh, there's a question right up the front. Gentleman here. There's a microphone coming to you now, sir.
Is it on? Yeah. Thank you for a wonderful talk. I just want to dwell on the right to be forgotten, the thing that you mentioned right at the end, the European Union passing this. I heard arguments, convincing arguments supporting that, and I've also heard convincing arguments opposing that. And as a layperson, I'm in a kind of quandary. So I would like to hear your views on that right, and as an unbiased view, perhaps. Thank you.
Yeah, I'm not sure I can give you an unbiased view, but it is a really interesting, issue because in a sense it's kind of the collision of privacy and free expression. It's also, I think, a pretty generally misunderstood judgment. The court really didn't create any right to be forgotten. Essentially what they've done is establish a process whereby people can have information removed from Google's index. That's really all it does. Now, it doesn't remove the original information. All it does is kind of suppress it from that search. Now, that's really quite problematic in a sense because it was just a court judgment. There was no sort of policy development process. There was no concern about, okay, how do we actually implement this? Who makes these decisions? Is Google the right organisation to be, making these determinations? I suspect no, and I suspect they'd rather not do it if they didn't have to. So I think there's some real issues there, and it's clear that this is something that is absolutely open to misuse and abuse, and that's clearly already happening. They've had hundreds of thousands of requests, many of them involving, press articles that may be entirely justified, but perhaps not to the liking of certain people mentioned in those articles, and they've been able to suppress some of those. So there's some genuine issues there, I think, that need to be worked through. I think the other issue, of course, is that there's potential for a bit of a Streisand effect here because the way Google's implemented it is that, for example, if you're doing a search at google.es, which is their Spanish site, or google.co.uk, which is their UK site, you won't see the link, but I believe there is some evidence, there may be a little bit of a space or something that suggests that there was something there. But if you go to google.com and do the same search, of course, you're going to see the information. So, sorry,
is it a Streisand effect?
Yeah, so the Streisand effect is...
Is that just me, or is that a common term?
No, it's a really good one. So the Streisand effect is essentially about the more effort you put into suppressing information, the more likely it is that people are going to find out about it. And it relates back to, Mark, can you help me out here? It's something to do with her beach house in Malibu.
Right.
Yeah.
She didn't want that episode of South Park in which she featured heavily to be suppressed. Streisand. Anyway.
That may not be unrelated, yes. So yeah, it's about the more effort, you put into suppressing something, the more likely it is people are going to find out about it.
But I think it's a really good example because my view is that it isn't a right, or it's an enormously complex issue, because part of the determination about whether there is this capacity to have information removed in part is whether it's relevant for the public domain. And so if you're a public official, you're not allowed to have it removed, or a senior public official anyway, if it's relevant to your job. Yet who knows what is relevant into the future. So some people now have almost a deemed higher degree of privacy than other people. So it's enormously complex. Does anybody else have a question? Otherwise, there's actually, Gillian has a question. Hang on, wait for the microphone, just for the people on the internet at home.
Thanks, Tim, and thank you for the presentation. This is obviously a very important issue for Australians, and we'll really have to see how this works out, given that the legislation, as you suggest, is very likely to go through today. We, as you may know, at the Australian Human Rights Commission made a submission pretty much agreeing that the laws needed to be revised to deal with modern technology. That
Sure.
makes a degree of sense.
Yep.
But my all-over impression of it, particularly having spent an hour with the Intelligence Committee giving our evidence, was that they've really used a sledgehammer to crack a nut. And they all kept wanting to talk about pedophile rings and extreme terrorism, but without really understanding the impact this is going to have on 23 million Australians. And my question is, why were groups such as yours not more closely involved with the government in the earlier planning stages for legislative amendments of this kind? And that's not an accusatory question, but perhaps put more softly, why isn't there a capacity for government and those drafting these changes to spend a little more time with the technology sector to understand how they could actually deal with the problems that they are identifying and with which probably most Australians would agree? But they use an instrument which is such a blunt instrument and so inappropriate to deal with the problem as they identify it, which does make one rather wonder if they actually have another agenda. In other words, it's so specious, the reason they're giving for this kind of extreme legislation, that one really wonders what's going on. So I guess my question is, what can you do to really inform government lawmakers a little better in order to help solve the genuine problems that are there?
Yeah, no, look, that's a really, really excellent question. Thank you. It's not because we haven't tried, let's put it that way. I think it's important to remember that this legislation is something that is really being driven out of the Attorney General's Department itself and has been coming for at least 7 or 8 years, I think, since the European Commission's Data Retention Directive, which was 2006, and which was really a response to, I believe, the Madrid bombings, was kind of the context there. But the reality
considered by the previous government as well, of course.
Oh yeah, no, there's a fair bit of it's quite cross-partisan. I think what was very clear to me, and I was in the room when you gave your evidence, your testimony to the Intelligence and Security Committee. What was entirely clear to me is that, and this is partly, I think, in the nature of that particular committee, but what I saw was unsupported assertions from police and intelligence being taken as fact, and everything else, including, empirical research and evidence that we were presenting, being just dismissed out of hand. So the US government's looked at this and said, doesn't really make us any safer. We know that Germany, there was some particularly interesting research there, and Germany's a really good example because they went through the 3 stages of not having a mandatory data retention scheme, having a mandatory data retention scheme, and then not having one again after their constitutional court threw it out. And they looked at crime clearance rates and found that, it was like 0.006% difference. It really, really made no difference whatsoever. So that's the evidence we've seen. I believe there was the Danish police put something out recently, and in Denmark they actually went a bit further and had actual browsing histories included in this. And the Danish police said, "Look, we can't. This just doesn't work. We can't. This is just too much information. It's really not helpful." And I think the reality is that when you look at terrorism particularly, and let's go through the recent examples. What happened in Martin Place recently, Charlie Hebdo in Paris, the Lee Rigby incident in London, the Boston bombers of the marathon. In each case, the perpetrators were well known to police and intelligence, absolutely well known. In the Boston bombers case, they'd ever been interviewed by the FBI. So data retention had nothing to do with any of that. I think the pedophile, terrorism and pedophilia are the 2 favourite flags that get waved, and they get waved at us a lot. The pedophile one is one I try not to engage with because that's just not an argument you're ever going to win. But is that really, the only weapon we have against pedophiles? I'd suggest not, and I'd suggest that most of the really, really nasty pedophile stuff doesn't even happen on the web. It's quite deeper than that, and I think there's a whole range of approaches that our federal police and other agencies use to tackle that sort of thing. I'm not sure that data retention has much to do with it. certainly helps. But yeah, at the end of the day, there's really not a whole lot of evidence here that this is going to produce or is as critical to crime fighting and anti-terrorism as our agencies assert that it is. There's a fair bit of evidence that suggests otherwise. I think one thing that is interesting in the current bill is that it actually does incorporate some meaningful reporting. At the moment, the reporting is literally just number of requests, nothing more. Under the new legislation, we will actually start to see some real empirical information around, what type of crime is being investigated, what the outcome was and so forth, so that over time we'll be able to go back and say, okay, well, has this actually had the effect that it's been asserted? So that gives us some reason for hope. But yeah, look, it's not for want of trying that we haven't been able to get involved with the process earlier on. And I don't know, Laurie, do you want to say something about that?
You had your hand up, so we might as well go straight to you.
This is a free kick.
Thank you, Laurie Patton. I'm the Chief Executive of the Internet Society of Australia, and a quick disclaimer that John is one of my non-executive directors, and I appeared at the Parliamentary Joint Select Committee into Intelligence and Security shortly after you did, Gillian. Look, I think the short answer is that neither the government or the opposition are particularly interested in any arguments for or against. They have decided to go ahead with this, and the best way that I can explain it was from a very senior politician who explained to me that, and there's a much more philosophical version of this, but essentially the deal is we give up our personal privacy rights in return for the government protecting us. And they both political parties have bought that lock, stock and barrel. So, as John said, there's a lot of evidence that metadata isn't involved in most of the cases that are being touted, certainly by the government. And the European Union just a couple of weeks ago, actually the directive to try to get harmonised data retention laws across Europe was thrown out. And the reason it was thrown out was that the court argued that essentially whatever benefits it might have couldn't be justified in terms of the invasions of our personal privacy protection rights. So here's the free plug. The answer is that I just exchanged tweets as we were sitting here with someone who made an observation that politicians don't seem to be to understand this kind of legislation, and indeed true. I'd say there'd be very few pieces of legislation that have gone through our parliament in recent years where fewer members of parliament actually had the vaguest clue about.
Or have even read it.
Sorry?
Or have even read the bill.
Or have even read it. So the Internet Society appeared at the select inquiry, and we gave evidence, and we were asked to give them a supplementary confidential report, which we did, and much of what we told them about the technology and how it would work actually led to the 38 recommendations for amendments. So how can you help join the Internet Society? Because we are the umbrella organisation that does actually have a foot in the government.
Did you have a question on top of your free plug of your organisation?
No, I never said I was.
All right. Can I ask, and it's a question for you, John, but no doubt might raise some other thoughts from others, which is, if you think about activity that goes online, which is criminal, no one's disputing that that should be pursued by proper agencies. Yep. Government or your organisation or anyone else. Now, of course, there are lots of different ways you can measure what people are doing online. One is to have an internet filter. I know full well that you guys are against that, and I know I'm certainly against that as well. Data retention is an attempt at an alternate way to deal with some of these challenges. Mm-hmm. Are you aware of anything that works successfully elsewhere to deal with the challenge of what happens when people engage in conduct online, which is criminal or otherwise, that needs to be properly addressed, which would be more effective than a data retention regime?
So, look, the reality is that at the most fundamental design level, the internet is all about avoiding this sort of control. So there's an old saying that the internet interprets censorship as damage and routes around it. And the reality is that all of these attempts by governments to sort of impose top-down control are trivial to circumvent. Hands up, who knows what a VPN is? Yeah, okay. That's a good business to be in right now. VPNs, of course, are...
But isn't that the wonder that technology actually circumvents the exact power that people are seeking to impose?
Yeah, and look, like all technologies, the internet is value neutral. It is, you know, it is what it is. It can be used for enormous good, and of course is. It can also be used for enormous harm, and of course is. So I think there is actually one thing that we would like to see more explored here in the policy debate around this area is when Australia acceded to the European Convention on Cybercrime 2 years ago. Yep. That established the concept of what's known as a data preservation notice. Now that is a targeted scheme that allows police or intelligence to go to a telco or an ISP and say, okay, look, these people are of interest to us, keep everything about them for 3 months, and we'll come back and tell you in 3 months if we need that extended.
So like essentially isolated data retention.
It targeted, yeah, exactly. And we, you know, we're not opposed to surveillance, we're opposed to indiscriminate surveillance. You know, targeted surveillance of people of interest absolutely is entirely appropriate. It's what the police and ASIO are there for, keeping us safe, absolutely no question there. So I'd like to see, you know, I've seen no real even discussion around this issue about how that power is in some way insufficient. It's my understanding that those notices have even barely been used. If that's the case, well, hey, if we don't need them, let's repeal the legislation. And there's a whole series of sort of expansions of intelligence powers, particularly since 2001, that fall into that basket. Have they really ever been used? In many cases, no. Why are they still on the books? You know, we need to go back and I think have a really comprehensive review, and I'm glad that the government was forced to back down on its desire to abolish the independent national security legislation monitor position. And I think that's a really important role because we have a whole series of interconnected bills and different regimes and so forth that create all sorts of powers. We need to have a look at that in a holistic view, work out which powers we really do need, which powers we don't need, and kind of start to tidy up that pretty tangled mess, I think.
And I actually met with the new security legislation monitor, and I know this is definitely going to be something he's going to be looking at. I just want to touch on another area which you're particularly interested in, which is around copyright reform, which is, of course, particularly in a digital environment, enormously complex, least because you're dealing with the tension between free speech and a property right, and of course, how that's accessible online and the barriers that exist. I know we've got one more question we'll take after that. What are the sorts of reforms and interests that the EFA and you are looking at pursuing in that space? Okay, so
this is one area where I do actually have a degree of hope that we are sort of moving quite positively. It's important to remember that the internet, again, at its kind of fundamental design layer, is essentially completely anti-copyright. I mean, the internet is copying. That's what it is. Particularly the web is copying. Every time you access a web page, you're making all sorts of copies of it all over the place. So there's a fundamental sort of underlying tension there between the rights of the copyright holder and the global distribution network that we have. We see, I think there's a genuine problem where we have, and I think this is particularly still evident in the sort of global kind of movie industry, where we have an industry that is clinging on to business models that are now getting into their 9th decade and really do need to evolve, and are trying, with some success, to force governments to implement legislation and processes that help them protect those what I would consider to be outdated business models. Now, we're seeing a lot of movement in the market, and look, we would argue that issues around copyright infringement and so forth are primarily, and there's a fair bit of evidence to back this up, primarily about price and availability. We're seeing, we've got Stan, which is worth a look. We've got Netflix coming. We've got Foxtel moving with its Presto service. I'm sorry to say that my old friends at QuickFlix, I think, are probably going to be swept aside as this happens. But we're seeing the market move here. But yet we're also seeing the government legislating. And I don't think, I think much of what the government is trying to do is essentially futile, has potentially quite serious unintended consequences, and in the end will make nobody rich except the lawyers. So there's that whole process that we're going through. But what a more positive perspective, what we are trying to see is some movement towards the adoption of what we call a fair use exception. Now, this is the fundamental basis of US copyright law. It's worked there pretty well for the last 40 years or so. The Australian Law Reform Commission came out with a quite strong recommendation that was published in February 2014, so that's over a year old now. And given that the original terms of reference of that inquiry didn't even include any consideration of a fair use exception, the fact that they came out with this really strong recommendation at the end of that process, I think, says that this is a really important reform that Australia needs to take. Now, there's a number of aspects to that. One is the reality is that all of us breach the Copyright Act on a routine basis every day. If you use Facebook, then I guarantee you've breached the Copyright Act today. In a sense, Australian society has already moved on to a fair use principle. We need the law to catch up. But there are also much sort of broader and more important contexts in the sense that current Australian Copyright Act is so technology specific and so outdated that it actually, for example, would make it arguably illegal for Google to actually operate in Australia. You almost literally could not create a search engine in this country because Copyright Act would essentially have you smacked down before you got anywhere. So there are genuine issues there about enabling the sort of growth of an innovative local digital economy. But that's really something that we would like to see some movement on. I have some cause for optimism that we might see something from the government soon.
So a summary would be you'd like to see a more open legislative architecture around this space and perhaps leave it more to the courts to decide how it can apply as technology evolves?
Yeah, absolutely. It's about getting the law out of the way.
Yep.
Because, you can't write technology-specific legislation because, even by the time you start doing that, you're 3 years behind the game.
Particularly at the rate that it moves.
Exactly.
Final question here.
Thanks. Natasha Malt here from the Law Council. Thank you for your very informative presentation. I just wanted to go back to data retention, if I may,
Sure.
and ask whether you'd had the chance to consider the privacy impact assessment that had been conducted on the bill and what you thought generally of the whole process of privacy impact assessments.
Was that published? No, I don't. I'm not aware that. I know that there was one done, but is that in the public domain?
I think it was. It was provided by the Attorney General's Department in a supplementary submission.
Yeah. Okay. No, I did see that. Look, I haven't looked at that in detail. I don't know. Has the Privacy Foundation looked at that, Mark?
It was a yes. I think so. We got it afterwards.
So look, I'm by no means a expert on those sorts of issues, but I do get the impression that some of those privacy impact assessments tend to be kind of box ticking exercises. And I think they tend to be fairly routinely sort of ignored as part of the policy making process. I may be being unduly cynical there, but that's certainly the impression I get.
Given all the consideration that they think it deserves.
Yeah, well, exactly. Very, very well put. So yeah, I think, and look, Laurie touched on this. I think the reality is that the political decision was made very early on that nobody wants to be the guy in charge when something really bad happens, so we should give the security agencies everything they ask for. I think that's the core underlying sort of political decision that's being made. It takes a brave person, and look, I think we have to give props to Senator Scott Ludlam, particularly because he's done a fantastic job in arguing the case. That actually, in some ways, what we're doing here arguably probably isn't making us any safer. It is arguably potentially creating very, very attractive honeypots of very, very interesting personal data that will be misused and will be hacked at some point by somebody. And that can lead to genuine harm to individuals. So it's arguable that these sorts of laws do, rather than make us safer, potentially put us at more risk. But that's probably a level of nuance and sophistication that I don't think the political debate's having at the moment.
And I presume, at least because those who wish to do us ill using technology, I would hope smart enough to figure out how to get around these schemes, and ultimately will choose to use different models of technology, while it's the good, the people, the right upstanding people who don't need to do these things end up getting caught up with it.
No, that's absolutely right. I mean, you don't need much technical sophistication to evade these processes.
I'm hearing VPN is the suggested
alternative.
alternative.
Even the classic one, which is just a shared Gmail account where you never actually send an email, but you just save things in your drafts folder. I mean, I think that's terrorism 101, right?
Well, I wouldn't know, and I hope nobody else just watched that. Ladies and gentlemen,
I watch too much television.
Ladies and gentlemen, friends of the Human Rights Commission, thank you so much for coming today. Can we please thank Jon Lawrence for his presentation? That's the end of today's Rights Talk, but we look forward to having another one shortly. And for those of us watching at home, we encourage you to tune in. Just go to humanrights.gov.au for further information. Thank you very much. Thanks, Jon.